Welcome, everyone. Hi.
Hello, hello.
Welcome.
Thank you. Good to be here.
Yeah. So tonight, everyone, we're going to be looking at Trump v. again. We're going to be continuing on this project that we started last week. And maybe we can just talk a little bit about what we've got planned for tonight very briefly. And we can just go over a couple things as we start. What were let's go back and just take a look at some of the things that we looked at last week. We took some notes, and maybe we just want to take a look at what the notes were from last time as we start. And
yeah, we had a nice little reading session to get started. We looked at both opinions from the majority. I think it was Roberts.
Yeah.
And then the dissenting opinion. I think, you kind of summarized it nicely there. We got into the different levels of immunity and how it may or may not apply depending on who you ask, because there was a dissenting opinion. And we did not get into the Federalist Papers yet. Or
no, we didn't.
letters.
Yeah. Not more than superficially.
So should we do like a summary a little bit more just to catch folks up, or catch ourselves up for that matter? It's been a long week.
Yeah, what I'm thinking about in this is maybe taking a look at what I'd like to do is kind of I was thinking we could take a look at this guide for new law students that is shared on the website of the University of Houston by Oren S. Kerr. It's got a few different things that we could use maybe to see what, like, for instance, a new law student might be thinking about. Just for the audience's clarification, neither Tim nor I are lawyers. We are amateurs who are trying to be deliberate and intentional in the way we do this work, and to do some real learning. And so we're always looking for more wisdom as we go through this. Yeah, go ahead, Tim.
Yeah, and we find ourselves more and more with legal concrete walls ahead of us that create these learning opportunities. And so this is a chance to be reflective about these stressful moments in our lives, whether it's this opinion or perhaps somebody's taken a nonviolent civil disobedience action with a group that is confronting us with these learning opportunities. And in exchange, we are reciprocating the learning opportunities by holding our truths in legal spaces for the legal actors to learn as well from us. So the more we're learning about the legal landscape, the better chances and the better equipped we are to help others that are already in the legal spaces.
Yeah, the long-term goal, a long-term vision for this work is that we could have folks who are serious legal experts in this space with us eventually, and so that we could have a place where working people could learn the same kinds of skills that, say, a law student might learn, not for the purpose of being a competing lawyer, but merely for the purpose of understanding how to make this nation better and make every nation better. And so with that, do we want to just read a little bit? Maybe I could start by reading this opening paragraph here, unless you like it a lot. And then maybe you want to get the first paragraph of what's in a legal opinion. Does that sound good? And we can maybe just start with that much. Okay. Mm-hmm. So this essay is designed to help new law students prepare for the first few weeks of class. It explains what judicial opinions are, how they are structured, and what law students should look for when reading them.
Yes. So this is like the user guide. And what's in a legal opinion? When two people disagree, and that disagreement leads to a lawsuit, the lawsuit will sometimes end with a ruling by a judge in favor of one side. The judge will explain the ruling in a written document referred to as an opinion. The opinion explains what the case is about, discusses the relevant legal principles, and then, of course, applies the law to the facts to reach a ruling in favor of one side and against the other.
Yeah, and so what are folks noticing? Feel free, if you're watching on social media, we've got a few people in the audience right now. Yeah, what are you noticing here? What are the facts here? I'm noticing here, and feel free to speak over me, Tim, if you think you see something interesting that you notice too. That there's a sense here that a judge is ruling in a written document, and that the origin of the lawsuit is in two people disagreeing and a judge choosing one side or the other.
Yeah, it reminds me a little bit of formal and official cherry picking, because in the history of the world and the legal systems in the world, there's got to be a lot of different cases, like precedents that a judge can choose. How does the judge decide what precedent to apply to the facts? In this case, they might try to align the mechanics of whatever the case is about, or the stories. Like if it's like damage to property, they might find, they might Google search. I'm just speculating, but yeah, I feel like.
So for you, a puzzle here is this process of going from legal history to that affect people's lives.
I mean, I guess that's why the judges are the judges, is because they've got a lot of experience to draw from, so they can make what in my profession would be called engineering judgment. When you are analyzing the situation, and you have to discern from all the relevant and irrelevant facts and conditions and come up with a solution that's practical and affordable and buildable or something. I guess a judge has to do something similar, like really.
You're saying examine all the minutia and evaluate them and compare them, and then come to some conclusion that has to be lasting and is important to all the stakeholders.
Yeah.
And so you see analog in that as an architect to being a judge too.
Yeah, I feel like the judge would be giving their professional opinion, but a different judge the same case in a different judge's courtroom might turn out with a different decision and different opinion. So the majority opinion and the dissenting opinion could flip. In the case of the Supreme Court, we've got a panel of 7 judges, and so these opinions can go back and forth. But for the case law course in the guide, how to read an opinion for the law class, is that it's all about one judge's opinion.
Yeah, so let's go back to that now. And I've got down here, I put down here, opinions may vary. I'm keeping some rolling notes here for us too. And so we can come back to these questions. Would you say this is a good expression of what we've explored so far?
Yeah, this is great. Yeah.
Okay, cool. So I'll just start on the next paragraph. And so let's see. So as we leave the other one, right, the opinion explains what the case is about, discusses the relevant legal principles, and then applies the law to the facts to reach a ruling in favor of one side and against another. And so this is kind of like a foreshadowing of this process that he wants to explore with us. And the next paragraph, it says, modern judicial opinions reflect hundreds of years of history and practice. They usually follow a simple and predictable formula. This section takes you through the basic formula. It starts with introductory materials at the top of the opinion and moves on to the body of the opinion. We could say what we notice about this and then move right into the caption. Anything you're noticing, Tim?
That it's a systematized, formatted, kind of like a reliable format for all cases. And the judges, they have their system of analysis and application of the legal principles, and that every case is different. And I guess we'll find out, what those components are next, starting with the caption.
Yeah. Would you like to read the caption paragraph?
Okay. So the caption, the first part of the case, is the title of the case, known as the caption. Examples include Brown v. Board of Education, and Miranda v. Arizona, and the one we're looking at is Trump v. U.S. government. The caption usually tells you what the last names of the person who brought the lawsuit and the person who is being sued. So the two parties. These two sides are often referred to as the parties or as the litigants in the case. For example, if Mr. Smith sues Mr. Jones or Miss Smith sues Mr. Jones, then the case caption may be Smith v. Jones, or depending on the court, Jones v. Smith. In criminal
law, let's pause here and just say, ask the folks in the audience and just think to ourselves, anything we notice here that, like for instance, I'm noticing that the last names of the people involved are part of the caption, he says, and that the order of the names doesn't necessarily mean anything. It could be either way, depending on the court.
Right.
So then, do you want to go on with criminal court now?
Yeah. So can we conclude that a civil lawsuit involves two individuals? But what I'm guessing is that contrasts with a criminal law, where cases are brought by government prosecutors on behalf of the government itself. This means that the government is named the party, or is the named party. For example, if the federal government charges John Doe with a crime, the case caption will be United States versus Doe. Or maybe if a state brings the charges instead, the caption will be state versus Doe, people versus Doe, or Commonwealth versus Doe, depending on the practices of the state. And I might add that I've also seen where they put the person's name first, like Doe versus United States.
Yeah. So Tim, you're even noticing here, you're even sharing some of your experience in seeing different cases at different times. And if folks are in the audience too, feel free to associate different legal things. Just put it in the chat,
Right. Yeah, isn't it Trump v. U.S. government? So
it's Trump v. the United States. So
yes,
let's take a look. Exactly. So now we actually, what's cool is we can actually look at this, right? So Trump v. United States. And I looked up this word, certiorari. I actually looked up the word because I was like, what does that mean? And so according to the Oxford Language Dictionaries, let's see if this plays. Certiorari. A writ or order by which a higher court reviews a decision of a lower court.
Oh, right, because you saw that name in the Supreme Court, so obviously it had risen to the top from maybe a court of appeals that was risen from an initial court hearing in some District of Columbia, I guess, jurisdiction, where it started with an initial judge's courtroom where it was just one judge ruling on the case, and then it was appealed to the next level, and then it was appealed to certiorari court of appeals. Okay.
So the certiorari to the United States Court of Appeals. So this is, as it said over here, right? A higher court reviewing a decision of a lower court.
Yeah, and the certiorari was referencing the appeals court.
Yeah. So now
good orientation here.
It's it's cool to it's kind of fun here to explore this law student stuff. I actually really enjoy this. I don't know that I'd enjoy law school this much actually as going through the steps of it. So okay, so now let's look at the case citation, shall we? I'll read this one.
Okay.
And then you can have do you want to just alternate?
Yeah.
Okay. So below the case name you will and numbers, these letters and numbers are the legal citation for the case. A citation tells you the name of the court that decided the case, the law book in which the opinion was published, and the year in which the court decided the case. For example, U.S. Supreme Court 485 U.S. 759 refers to a U.S. Supreme Court case decided in 1988 that appears in volume 485 of the United States Reports, appearing starting at page 759. And so now
is that what we're seeing here? Yeah, case number.
Yeah, so what are folks noticing between noticing here?
Well,
What do you
I'm
know? Yeah.
guessing number 23 is a section of law that maybe goes back somewhere, or are they going to tell us at the top? Maybe no.
Yeah, so it looks like let's see if maybe we can find this by this,
939 is the page number of that law, I'm guessing.
Oh, okay. So uh docket for 23939. So apparently this is it's like we can speak docket basically. And so that's where it's published. I wonder, like, it would be one question I would want to ask, and let me add this to our little thing. A question we might ask is potentially a question we could ask is, since the Supreme, is there no publication cited? It's on SCOTUS's website.
Yeah, or maybe because it's a criminal court, then certain law applies, like U.S. criminal law, as opposed to like one of the different types of civil laws, where you could get into, I don't know, state civil law, case law, and like business, like,
You mean that it's not appearing, like, because like in this case, right, like it appears in the United States reports, right? So but I'm hearing you say that maybe the type of case, if it's a criminal case or whatever, might affect which publication it's in. That might be another question for a lawyer to ask, to ask if they just know.
yeah, like if you're suing somebody over
It seems
copyright,
like a kind of local knowledge, though, to me.
totally, in
Like,
particular to the type of law. Like if
well,
you're just,
or just to the fact that maybe the Supreme Court has changed their policy since COVID, and they just publish things on their website instead of putting it in a publisher and a book. But this is all speculation, so it's interesting to speculate. But again, it's just speculation.
like, to me, it reminds me of the building codes. Like if you've got a question about plumbing, you have to go to the plumbing code. Or if you have a question about fire safety, life safety, there's a fire code that you can look up things.
Well, yeah, it isn't often the code specifically in books under like section whatever, like well, it's interesting. Like, we don't have to get into it too deeply at the moment because so we've got the case citation here. I mean, we could definitely have somebody check this for us in the future, but the case numbers, this is the case numbers, right? Like, and I've done enough like legal help for lawyers that I know that it's always got a thing like this. So that's how I kind of have a sense of it.
Yeah.
But this does look like the case number to me. I think that's correct.
Well,
do you think there's a good reason to think it might not be?
The case number I've seen before is sort of like a coded, more of like a
U.S. code.
Yeah, it's got letters and numbers all bunched together, and they include like who the judge was, the initials of the judge's courtroom, and the number of the court case for that year under that courthouse or something. They're all numbered, and something else. But yeah, so I guess it depends on the system of law that you're working in.
Yeah, I'm trying to. I think there's like, I'm trying to remember all the net neutrality law. There's like a Federal Communications Act, and so there's like very often, if we look at this example, let's see, S 652. Now this, I don't know, this might be this looks legislative, so it's not actually a judicial opinion.
Oh, you know what? I think I might be conflating this ruling or opinion number with a case number, because the ruling is already within the Trump v. U.S. case, so that case number is different from the citation number for this opinion. Sorry.
I see. Yeah, and it's and like, for instance, here you can see 200 U.S. So that's referring to the I think that refers to like US 75, like in this example, right? 200 US 321. Right? That in that case, that's United States reports.
Okay.
The author of the opinion. Do you want to take this part?
Sure. The author of the opinion. The next information is the name of the judge who wrote the opinion. Most opinions assigned in law school were issued by courts with multiple judges. So yeah, appellate, appeals court, or Supreme Court have multiple judges. The name tells you which judge wrote that particular opinion. In older cases, the judge often simply states a last name followed by initial J. No, judges don't all have the same first initial J. The letter stands for judge or justice, depending on the court. On occasion, the opinion will use the Latin phrase per curiam instead of a judge's name. Per curiam means by the court. And it signals that the opinion reflects a common view among all the judges rather than the writings of a specific judge. And that concludes who the judge was.
Yeah. What did you notice in this section? Was there anything that stood out to you?
Well, that there are oftentimes multiple judges, but the one who wrote the opinion, the author, lead author, is whose name is on the opinion.
Yeah, or the particular opinion. Yeah, and so I found it fascinating here that there were like J stands for judge or justice, and also that you have something that's like a per curiam, which means that there's a kind of like consensus in the court. I thought that was kind of cool.
Yeah. Yeah. If we had a lawyer in the room, I'm guessing they could give us more context for these things, and we would get through it a little faster.
Yeah. Well, it's kind of it's different though, because like but it's kind of interesting because the more we learn about this, the less we'll be able to have these kinds of experiences of surprise and using like law school stuff.
Yeah.
Now let's see. So should we look here for the first instance of a justice's name on here?
Oh, right.
Maybe we should scan this for a justice's name.
Good point.
On here. Do you want me to try to go as fast as I can?
Yeah. I'm just noticing syllabus. You passed the syllabus, And maybe we haven't gotten to the opinion yet, but maybe
that's it. You know,
yeah, maybe there'll be a name starting off with the actual opinion.
How to read a Supreme. Oh, this is cool. Also, I missed this one. This is cool. How to read a U.S. Supreme Court opinion from Oregon.gov, teaching legal docs.
Good one.
So maybe.
Yeah. See, the syllabus starts off, and then what comes after the main opinion?
Yeah. So there's the syllabus. Should we just read these parts out loud a little bit?
Yeah, it could be a little bit more focused.
And then we can let's go stop in on each section maybe a little bit. And again, if you're in the audience watching, as I see there's a number of people in the audience right now, if you're in the audience, feel free to engage with us. This is an experiential process. So like you can jump and interact with us, and we're here to help you learn. And I'm just going to shamelessly also plug our website. This is codewhatever.us. Feel free to stop by. We're a nonprofit based in the state of Illinois, and this work we do this very often. Most of the work is volunteer. So every donation and every little bit helps us out. And if you're able to give time or money, you can donate on the website. You can message us, message me, ba@codewhatever.us. I'll put that in the chat for folks right now.
Thank you. I should also add that the purpose of this gathering is to not just to look at and respond to the latest opinion by the Supreme Court on the Trump or presidential immunity as it applies to the Trump case, but this is just like one example of learning, experiential learning, and group learning in a safe place around the topic of human rights in all of its various forms, right?
Yeah, and thank you for bringing up experiential learning, right? Like, it's not like we're here trying to transmit knowledge to people from our heads to yours, right?
Yeah, I hope they're not waiting for that.
Yeah, we're actually here trying to help us all find experiences that that the subjects itself are the only authority. And so it's not every day that you get a chance to experience things and reflect together with a community of fellow experiencers so that we can have shared experience together and build on that to find concepts that give us the power to act with agency and sophistication so that we can apply these things in the real world and move on in learning going forward for our whole lives.
Yeah, and if we could do that on this topic of law, we will have achieved a great thing. I mean, sometimes human rights are a little bit more practical, shall we say, concrete, and less heady and abstract and theoretical when you're, talking about legal precedent as it pertains to the facts of the case. And so, yeah, like in the past, we've looked at such issues as health and safety, fracking, working conditions, and human rights in Gaza, and the climate injustice, human rights around the climate emergency. So, and there are
a lot of stuff, right? We've gone through the Doha debates here in the past, and we're going to continue going through those Doha debates about the economy and growth versus growth economies versus degrowth versus just in time versus other things.
Yeah, like who knew that human rights were intimately entangled with economic systems?
Yeah. Well, and how do economic systems, what opportunities do economic systems offer for change, and what constraints might they be causing us at these times? I think these are important things to learn, and we're here to learn it together with you, and we're here to not just do learning together. If there's something you want to learn and learn it with other people, we'll help you do that in a community setting, and we also want to help people develop expertise so that we can teach each other things more effectively while doing that in a community setting with experiential learning. So
ultimately, this helps build the fabric of democracy and civil society that has been unraveling for decades.
Yeah, and we have lots of, I'm a very working class technocrat. I'm a very poor technocrat, but I'm a technocrat nonetheless, for better or for worse. And a gig worker, so not a secure technocrat. But, technocrats very often hold this stuff in our hands and we don't share it with people. And we need to blur the line between people who are experts and people who are citizens who care about the effective administration of public services.
Blurring the lines is important because when everybody stays in their lane, we tend to be divided and conquered in society by the people who have a lot of money and special interest in spending that money to maintain control by keeping us divided and conquered and talking in our own silos. And otherwise we might do something very threatening to them, which is organizing ourselves around human rights and our common shared values about how we want to live and why we can't, how to get there from here by confronting the keepers of the existing power structure, right?
Yeah. It's what we're doing here is very radical, just as looking at the syllabus is very radical.
I feel like we're procrastinating. We should get back to it.
Philosophizing. We're philosophizing, but yeah. So the syllabus. I'll read the syllabus part, unless you want to read the syllabus part first.
Whatever.
So the syllabus appears first before the main opinion. It is not part of the official opinion. Sorry about that. It is not part of the official opinion, but rather a summary added by the court to help the reader better understand the case and the decision. The syllabus outlines the facts of the case and the path that the case has taken to get to the Supreme Court. The last portion of the summarizes which justices authored the main opinion, which justices joined in the main opinion, and which justices might have issued concurring or dissenting opinions. So what are you noticing here, Tim? I hear you typing. Should I go pull up? I see. So yeah, the syllabus summarizes the case facts and path the case is taken to arrive to the Supreme Court.
So you're noticing, it's like foreplay. It's like this is what we're talking about, setting up basic ground rules or basic context, I guess.
Yeah, well, and I'm imagining as I hear this, what I imagine is that the syllabus gives us a overhead view, so we don't have to read, but we can have a sense of some of the larger systemic pieces, and maybe we could take a look at, maybe let's test this. How do we want to test what the syllabus is here? Like, for instance, I can think of maybe one thing that this tests, but do you have any thoughts of how we might test this if we're thinking about what a syllabus is?
Well, let's just dive into it and try to see if we can pull out the key ingredients, and that's how we can basically construct an analysis of this example of this opinion that we're trying to
Yeah.
learn.
And maybe what we could do is see here too, just are there a few facts of the case in the syllabus without having to look at the whole syllabus? Maybe there's a few facts of the case here, so we can say, okay, this is a syllabus. Here's what a fact in the case looks like, and then try to find the part of the syllabus where it shows who authored what, if that's in this.
Yeah, and something about a path of how it got there, a little
Yeah,
context.
maybe to see if we can see where that path is, so people can understand where to look that up.
Yeah.
Okay, let's do that.
Like,
So,
did the Trump case start in Washington, D.C. because the government brought it because that was their jurisdiction or something? Maybe we'll find out.
Well, here, right, with now wait, let's see. Okay, so it says here that a federal grand jury indicted former President Donald J. Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the presidential results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has no prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding the former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit Court affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved official acts. So what are you noticing there, especially with how it fits in the schema?
Well,
does this match any of our tests?
Our tests? Oh, for what we just learned about the syllabus?
Yeah.
We basically were just given the path and about how it started with a grand jury indictment and what it alleged, and let's see. I don't know if it got too specific about the charges that were being alleged, but maybe they're all there. I can't tell for right now. But basically, Trump tried to moved. That he had a motion, like that's an official legal lawyer's motioned or moved to dismiss the indictment based simply on the principle of presidential immunity. And then what happened? The district court.
Yeah, well, and I think, right, and yeah.
And then there was an appeal, or no?
Well, so it said, the district court denied Trump's motion to dismiss, and then.
The circuit court must be the appeals court.
Yeah, and the D.C. Circuit Court affirmed that that former President Trump, that district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. And the D.C. Circuit affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved official acts. So, and that's kind of interesting too, because as I look at that, I think to myself, so if they didn't answer the question as to whether these were official acts or unofficial acts, right, of the presidency, because they declined to answer that question, the Supreme Court is answering that question.
Right.
in this.
Right. They're like the final stop, the final say.
And then we see this next piece here, and in the syllabus, and it says, it starts off with the word held. Does anybody in the audience know what this might mean? I looked it up. So I looked it up, and what I found is that held, this is in dictionary.law.com, decided or ruled as the court held that the contract was valid.
Okay.
And so I take that to mean that this is what the court's ruling is.
So it's like the results.
So yeah, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for acts within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. And then it's got all these different sections here from A, and going all the way down to, here's B. And we're still in the syllabus here.
Wow.
And then we get to, let's see. Is there a C? Let's see. Here's C. And D. Yeah, so in this case, right, like if we just read the first sentence from each of these, Trump asserts a far broader immunity than the limited one the court recognizing, contending that the indictment must be dismissed because the impeachment judgment clause requires that the impeachment and Senate conviction precede a president's criminal prosecution. And they leave some questions here. The government takes a similarly broad view, contending that the president enjoys no immunity from criminal prosecution for any action. That's D. And there's E. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during a presidency? Answering that question, unlike the political branches and public at large, the court cannot afford to fixate exclusively, even primarily, on present exigencies. And so they're saying the enduring separation of powers guides our decision. The president enjoys no immunity from his unofficial acts, and not everything the president does is official. The president is not above the law, but under our system of separated powers, the president may not be prosecuted for exercising his core constitutional powers, and he's entitled to at least presumptive immunity from prosecution of his official acts. That immunity applies equally to all occupants of the Oval Office.
What do you notice in there?
Yeah, it's I'm noticing that they're saying that the president is not above the law, but that there is presumptive immunity for a president.
Yeah, it sounds like that immunity, that presumptive immunity, depends on how official their behavior was or their actions were.
Yeah.
Because if it was unofficial business, like, I don't know, he's playing golf, or maybe that's official. What's an example of something that the president would do that's unofficial?
Yeah, I would imagine I would imagine that campaigning can't be an official act, right? I don't. Let's look it up. What
maybe that's
examples of presidential official acts? I mean, that's part of the problem of, yeah. So,
my guess is that the majority opinion and the dissenting opinion will have different opinions on what's official business and what's not official business.
Yeah, the Washington Post offers this: what is an official act, and how will a judge interpret that?
That was from last week. Yeah, it was definitely about Trump's case.
Yeah. Well, while that loads, let's. So okay. So and it also says the syllabus has which justices joined in the main opinion, which justices might have done something concurring. So if we come back over here, we've got this little part of the. Is this the end of the syllabus? Yes. So this is the end of the syllabus. So do you want to read the end of the syllabus out loud?
Yeah. Let's see, where are we? Roberts C.J. delivered the opinion of the court in which Thomas, Alito, Gorsuch, and Kavanaugh joined in full, and in which Barrett joined except as to Part 3C. Thomas filed a concurring opinion. Barrett filed an opinion concurring in part, and Sotomayor, if I said that right, filed a dissenting opinion in which Kagan and Jackson joined. And Jackson filed a dissenting opinion also. And all the J's I left out because we defined that earlier as just meaning judge or justice.
Right. Yeah. Okay. So I think, would you say in terms of the syllabus, in terms of exploring the syllabus, we said our metrics for the syllabus as being like, does it lay out how the case traveled, and does it have who did what in terms of opinions and decisions? How do you feel about that?
If you switch over to our document, I've put a few notes. I think we've caught them all.
Yeah, I think so.
And we can just go down the list. So for our opinion syllabus in question, we know that it got there from a jury indicting Trump on 4 counts of election fraud, and then Trump disputed the charges based on presidential immunity for
their official acts.
For their official acts, yeah. And then the district court denied, or let's say the district court denied Trump's motion to dismiss. The circuit court confirmed the denial. And then I think I might be missing a step between that.
Which judges decide which decisions?
Yeah, we just finished reading that. But before that, I think there was something like held. Yeah, the part on held, like what was the result of that, is what we would summarize as the actual opinion that was summarized in the syllabus.
Mm-hmm. Yeah, what was decided. So do you want to move on to the main opinion now?
Mm-hmm.
I'll start by reading it. Following the syllabus is the main opinion. This is the court's official decision in the case. In legal terms, the opinion announces a decision and provides an explanation for the decision by articulating the legal rationale that the justices relied upon to reach the decision. The main opinion may take different forms depending on how the justices decide certain issues. Sometimes decisions are unanimous. All the justices agree and offer one rationale for their decision, so the court issues one unanimous opinion. When more than half the justices agree, the court issues a majority opinion. Other times there is no majority but a plurality, so the court issues a plurality opinion. Typically, one justice is identified as the author of the main opinion. Per curiam opinions, however, do not identify any authors and are simply opinions of the court. So, yeah, what are you noticing in all that?
That the main opinion includes, the decision that needed to be reviewed. I guess that's what the motion came up from the district court in the beginning. So that was it was bounced up to the next level and bounced up to the Supreme Court, and the Supreme Court is deciding whose side that they're on, who's right in this case. And then that main opinion, is authored by, in this case, Trump case, there's a majority, and then the author. So I guess we could write that down as our particular. And this is still in the syllabus, right? So
well, no, now we're out of the syllabus. So this is now this is the opinion.
Oh, the main opinion is the main opinion. Got it. Thanks.
The opinion of the court. Yeah, what do you notice? What else do you notice on this page?
Let's see. So Trump is the petitioner who filed the motion, and they reference the path, through the certiorari. Certiorari.
Let's see. I can have it pronounced for us.
But that came up through the appellate court or the appeals court.
Oh, sorry. Yeah, certiorari.
Yeah, it does. When you play it, it doesn't. I don't hear it.
Oh, you don't hear it.
But then you repeat it, and so I think I'm hearing you.
Oh, interesting. Yeah, let me actually. I can actually just share it in the. I'm going to share it in the chat. It's got the source. I'll start doing that more in the chat. Is just posting the links to stuff in the chat.
Okay.
Cool. This is so people have it. So okay. So, and one thing I noticed is that it mentions Chief Justice Roberts delivered the opinion of the court.
Yes.
And so maybe let's just look at the structure of this for a second. Because he says here, this case concerns the federal indictment of a former president of the United States for conduct alleged to involve official acts during the tenure of the office. We consider the scope of the president's immunity from criminal prosecution. And I want to just say one thing at this point, which is that, okay, so we've been here for an hour. We're doing quite well. But I want to just give us a chance, because we'll probably go another half hour or so, right? And
whoops. She'll be right back.
I just want to, sorry. The worst thing about using StreamYard, honestly, is that if I use my trackpad in the wrong way, it throws me out of the session. But as we were saying before, there's a couple things we can do. So we talked about possibly looking at the Federalist. That might be off the table tonight, unless we at some point.
It could be homework, and who knows, maybe by next time we will have some legal student or a practicing lawyer or professor who could help us pick up where we left off.
Well, and we've got some folks in the community who we can ask for help with,
It could be homework. Yeah.
So that's one piece. And I just want to look at some of the choices we have to explore now real quick. So I want to keep going through this, but let's just step back for a second. And for folks in the audience, if there's stuff that you're hoping for, there's any puzzles or any stuff that you're thinking about, let us know so we can maybe consider that too. So there's the main opinion here that they talk about, and the concurring and dissenting opinions. That's one way to look at it. Now, it also says understand the formal elements looking at the
Oh,
case number and things. So we've looked at some of this stuff, right?
You might have to get back to the share screen.
Oh, you're right. Oh, thank you. Thanks for bringing that up. So, thank you.
Okay.
But we've done a little bit on understanding the formal elements. But I want to point out, like, there's the facts of the case, right? The who, what, when, and where. And so that's something that the other guide mentions too. And then what are the legal disputes?
And that's going to be in the majority opinion.
Already even looked at it a little bit, right? And the disposition, of course, is the disposition or what action the court is taking.
Yep.
And so there's that, right? And
that's three types, of decisions. Yeah. Cool. So maybe we could go through and see if we can find out which type of decision was made. It sounds like they're going to be.
Yeah. Well, and what we could do is maybe just look at some of what I'm wondering too is, like, as we're looking at this, right? Like, we could just read the first paragraph from every Roman numeral to try to get like a bigger sense of it, because there's probably hundreds of pages in here. So our scope's going to be limited, and so there's a couple. So maybe we want to just get a bigger picture of this for today, and then step back and look at our notes, and then say to ourselves, like, what are our learning goals here? And so, because we might have, what we might do for this, and folks in the audience, feel free to bring in your one thing that we can do in this exploration that I'm thinking about is, okay, so Tim, you and I have kind of been creeping through this and getting a bigger and bigger sense of the structural elements of it. We could explore this, and it doesn't have to be next week again that we explore it next. We could give it a couple weeks off and come back to it or something, and keep deepening it if we want to. There's different roads that we can take in this. And so maybe when we look at homework, folks, on Sunday, every Sunday, we have, and you can go to codewhatever.us. I'm going to put it back in the chat for folks. Codewhatever.us. You can visit our website and sign up on Sunday. We have another pitch-in that's just a Zoom session. And so we can do more of this work there. So, and if there's other stuff that you're interested in learning about and bring that to this forum, that's a place that you can help us develop that. So, codewhatever.us, and you can see. But yeah, so Tim, do you like the idea of looking at the larger sections? I know you had some other ideas about it too, and I want to try. I think we could probably do all those ideas. What do you think?
Normally, when there's too much to chew, too much information to process, I try to focus on one part of it and do it well, and trust that if I had more time, I would do the rest of it well. So if we're going to take that approach, we would just try to get like through one of the facts and make sure we know that this majority opinion is focusing on X fact of the case. And if that's all we have time for, that's all we have time for.
I see your point. What if we do a little bit of hybrid of that? Sometimes we bounce around to the Roman numerals to get a bigger sense, but then we do a little bit of that, and then we pick one to get into.
Yeah, okay. Yeah, well,
so maybe let's
circle around.
Yeah, and then we can have a sense of, like, okay, this is the bigger sense of it a little bit, and I just want to.
Maybe we
I
come
just
out
want
at
to
the
get.
end. I'm sorry.
No, you're good. Maybe we just want to see how many Roman numerals this is, just to like to get, because
Yeah.
like what's daunting about this is like what, like 100 and something pages. So let's just, so there's the one.
Yeah, I think the dissenting of opinion doesn't start until 68, page 68.
Yeah.
And so,
So
yeah,
here's two.
not quite 100 yet.
Let's see. I just want to see how many Roman numerals there are.
Yeah.
Okay. Now we're in the B. Let's see. Here's C3. Okay. And then now if I go down here really fast, I'm gonna move faster now. Okay, so now I've got 3. We have all these little subsections in here.
Speed reading, awesome.
Well, I'm trying to think like an architect here. I'm trying to look at the big picture and step back
Through
from
the
it a little
code,
bit.
yeah.
There's
Roman numeral.
Oh wait, where's that Roman numeral? Thank you.
Roman numeral 4. I just saw.
Okay, cool.
4.
Okay, now let's see if, okay, there's 5.
5. Yep. See, we're speed reading. I haven't done this since
And now, okay, and so now here's a concurrence. So the end of this section would be at, what page is this? Page 43.
Whoa. Do you say concurrence? Is that one of those official sections?
Yeah, so this is the Judge Thomas. Justice
Oh,
Thomas.
right. There are a few of those. Yeah.
So now now we've got what, 5 Roman numerals, right?
5 sections. Yeah.
So let's look at all those 5 paragraphs, and then maybe we can pick something from that.
Okay.
Does that sound good to you?
Yeah.
And we may not get through a whole section, but we can start looking at it and just trying to get a sense of how it works. And maybe then we can figure out what we want to do from there.
Yeah, if we could get like one defining sentence for each of those parts, each of the sections 1 through 5, and write them down, then that's sort of like an outline, a summary outline of the.
Yeah, we could even take a paragraph like this, right? So
can you copy it and put it in?
Oops. See, for some reason, let's see, it might be because this is a PDF. Let me see.
Oh, right.
I don't know. We'll see if it's gonna
That's
give me
okay. If you read it, I'll type it or something like that.
Okay, we can do that. And yeah, what we'll do is we'll read it, and then we can go to each one after we read each one. Does that sound good?
Okay. Yeah.
So, Roman numeral I, from January 2017 until January 2021, Donald Trump served as president of the United States. On August 1st, 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of election results. So, now when you're ready, I'll read Roman numeral 2.
Yeah, could you repeat, what did he allegedly do? Or just how would you summarize that?
So
After
the indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results.
Okay.
So now, do you want to read the next paragraph, or do you want to keep typing?
No, it's fine. I'm just
Okay.
Yeah, I think I just finished my one-line summary of
Nice.
part one.
Okay, cool. Do you want to read it to us, or I can?
Oh yeah. Okay. So what I'm hearing is that Trump served as president from 2016 to 2020. Following the 2020 election, Trump conspired to overturn the election by obstructing the election results. Okay. I think there was like one other thing that he did. Was part of that, but
okay, no, this is good. Let's
keep it simple.
Yeah, I agree. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We're called upon to consider whether and under what circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of the presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic.
So I'm hearing that this is the first criminal prosecution of a former president for actions taken when he was a president, and that it's a really hard decision, and we have to be careful.
Mm-hmm. Yeah, enduring consequences upon the balanced power structure of our republic. And that's something that Jackson concurs with.
Okay. Is that section 2?
We're still on, yeah.
The gist of it?
And now we're on 3. So yeah, in that time, about, like, we're now on page 16.
Cool. All right. You want me to read this part 3?
Up to you. Do you want me to read it, or do you want
to read it? I can read it if you want to type the notes. And you want to do the sentence?
Sure.
Sentence? Okay.
Yeah, sure.
In the document? Yeah. So part 3, determining whether...
wait. Hold on. If I do the typing, I need to... If I do the typing, then I shift the screen.
Oh, no, go ahead and read then.
I'll read it then. Yeah, let me just read it. So, determining whether a former president is entitled to immunity from a particular prosecution requires applying the principle we have laid out to his conduct at issue. The first step is distinguished from his official from unofficial actions. In this case, however, no court has thus far considered how to draw that distinction in general or with respect to conduct alleged in particular.
Oh, you know what I'm thinking? I'm noticing is that, remember when it said the path of what's in question arriving?
Yeah.
And then the application of precedent or of principles of law that might apply to the case.
Yeah.
We're at that point, except there are no precedents. They're basically saying that we have no past principles or cases that are applying here.
Yeah, and if you even look at the next paragraph, it starts off, despite the unprecedented nature of this case.
Right.
So they call the case unprecedented.
Yep. All right, cool. So is that section 3? And
that's, yep, next section.
And the first part of that, determining whether a former president is what? Is
engaging in official acts or not.
Is engaging in...
Wait, I think we're translating it correctly, but we're not looking at it now. So do you want me to go back to it?
Yeah, because I feel like the question might be is engaging in official acts, because I know that those details play out in the majority opinion and dissenting opinions, but it might also be simpler than that. It might just be whether a former president is allowed to claim immunity, because that's what was denied, and that's what was brought to their attention, is that fundamental question of whether immunity applies in this case, I guess. Yeah, in the case about obstructing the transfer of power and the election results and all that. So, you know what I mean? Like, do we have that initial Section 3 concept correct in our notes?
Yeah, so we have the quotation right here. What are you noticing in terms of what you're already thinking about it?
Oh, there it is. Yeah. Determining whether a former president is entitled to immunity requires applying the principles. Okay. Requires applying the principles. What principles?
Well, these might be principles that we've missed in skipping over stuff, right? Because it says we have laid out
in his
to his conduct at issue.
Okay.
So I think it's just previous material. All right, should I move on now?
Yeah. Okay, go ahead. I'm ready.
I'm just flying down to the next section, but we haven't made it to the next section. This is a long section. We're just at C now. Here's 4. Trump asserts a far broader immunity than the limited one we have recognized. He contends that the indictment must be dismissed because the impeachment judgment clause requires the impeachment and Senate conviction precede a president's criminal prosecution. Brief for petitioner 16.
He contends what? Sorry.
He contends that the indictment must be dismissed.
All right.
Yeah, and yeah, so.
Okay. Well, there you have it.
Okay, so then, okay, so let's go to 5 now, and then we can decide what we want to do next.
All right.
Okay, here it says, the case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer. But in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. In a case like this one, focusing on the transient results may have profound consequences for the separation of powers and for the future of our republic. And it says Youngstown 343 U.S. at 634, Justice Jackson concurring. Our perspective must be more far-sighted, for the peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. Chief Justice John Marshall, a friend of the Constitution.
So is in this opinion, have we, okay, was this just the layout of the facts, or have we gotten to application of, I guess we have, and is there a result?
Yeah, because this is the whole, well, the held is the result, right? It is so ordered is where it ends. Oh, I see. Yeah, you can see here. So they're saying, do you want to just read the whole of 5? Maybe the whole of 5 is not very long, so we might as well read the whole.
Yeah, maybe it's got the sort of the result.
Do you want to read the first paragraph again? And folks in the audience, as you're watching this, share what you notice. Share what you're noticing about this.
Yeah, we're happy to stop for questions and reflect back what you're noticing. Yeah, so
we'll trade paragraphs. You can go.
This case, section 5, this case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer, but in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies.
Yeah.
In a case like this one, focusing on transient results may have profound consequences for the separation of powers and for the future of our republic. Youngstown 343, US at 64, Jackson concurring, our perspective must be more far-sighted, for the peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. Chief Justice John Marshall, a friend of the Constitution, number 5, Alexandria, blah, 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 1918, and John Marshall's defense, McCullough versus Maryland. So they're going back to something that probably sheds light on this situation. Maybe, do you want to read the next paragraph? Maybe it'll be more specific.
Our first president had such a perspective. In his farewell address, George Washington reminded the nation that a government of as much vigor as is consistent with the perfect security of liberty is indispensable. 35 Writings of George Washington 226. A government too feeble to withstand the enterprises of faction, he warned, could lead to the frightful despotism of alternative dominion of one faction over another, sharpened by the spirit of revenge. The way to avoid that cycle, he explained, was to ensure the government powers remain properly distributed and adjusted.
It is these enduring principles that guide our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law. But Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president, therefore, may not be prosecuted for exercising his core constitutional powers, and he is entitled, at a minimum, to a presumptive immunity from prosecution for all his official acts. That immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party.
The judgments of the Court of Appeals for the D.C. Circuit is vacated, and the case is remanded for further proceedings. Consistent with this opinion, it is so ordered. What do you notice?
That they went back to the framers, and I'm not sure what their perspective. I guess the framers were talking about immunity as well to help the executive branch be vigorous in carrying out their duties. And it's all part of separating powers and distributing powers of governance.
Yeah, one of the things that is kind of crucially that we talked about last week, that's kind of crucially explored, was this notion that both sides refer to the Federalist Papers, and that in the Federalist Papers, on the one hand, in Federalist 77, Hamilton says we want a robust executive. The other hand, he says the executive should not be. I struggle to quote it exactly, but I think the effect of it is that the executive should be liable to criminal prosecution. I think was my sense of it, but somebody should correct me if I'm wrong about that, because I'm not saying it from exact memory. But
so that's a puzzle.
That's a puzzle, and that's actually a puzzle between the dissent and the majority opinion. And so maybe now we've taken a little bit of a look at this. Maybe now we want to just come back to our notes a bit and kind of just take a second to maybe think about what we've explored today and what we want to explore for Sunday and going forward on this.
Okay. I mean, yeah, the goal would be to understand the opinion. Mm-hmm. And by doing this analysis, I feel like we're getting the 5 parts of the main or majority opinion.
Or the 5 beginnings anyway.
Oh, it's just the beginnings.
Right. So we've just got the beginnings of each section here, but it does give us a sense of where each section starts. We could go to the end of it too, right, and that would probably have a logical kind of arc or something.
Yeah. How many pages is the main opinion? Just curious. If we were going back to,
if we were to go through the whole main opinion,
really flesh it out. Yeah.
43. Well, including the syllabus, 43 pages.
Yeah. So where does it start on page like 20 or something? There's the syllabus.
Oh wait, no. So it's 43 pages. Excuse me.
Oh, it does start counting at 1.
Mm-hmm.
Okay. So for that section, it's its own section. Main opinion, 40 pages. Gotcha.
Yeah.
41 pages.
43.
43. Okay. Okay. So in the opinion might have 200 pages. So this would be 43 of those 200 pages.
Yeah. And this is the opinion of the court as a whole, right? And then there's the concurrences and the dissents.
I don't think it's of the court as a whole. Well, yeah, because that's the majority. So right, that's what ultimately is decided or held.
Right. Yeah. I guess. Yeah. Maybe the language of as a whole is not actually the best language. That'd be a good question. That'd be another puzzle for a lawyer.
I mean, I think we read somewhere in the definition of the syllabus or somewhere that said if everybody agrees, then they call it something different. It's like a collective decision. Or
they
something.
Call it per curiam. Per curiam.
Okay.
By the court. Yeah.
Okay. Yeah. Right.
Yeah. So we're starting to understand more of the formal elements here of this case. Is there anything we could do between now and Sunday, if we take this back up on Sunday, to kind of give ourselves a challenge for next time? Is there anything you can think of that you're hoping to maybe explore between now and next time, if you want to?
Yeah, thanks for asking. Yeah, we've just skimmed the surface of the 5 sections, but I feel like if we went back and each of us came up with 3 key findings of each section and sort of included them in our outline as like subpoints, for section 1, we've got A, B, and C, for example. Then I think we would be a little closer to understanding the majority opinion or the main opinion.
Yeah, we actually could do in between now and next time too, honestly, is just read the 43 pages if we wanted to.
Right.
Like, because we're already so close on it, and we've actually done enough work on it that that might be a wise thing to do.
So when we get back together, we maybe have a list of 3 or 4 or 5 points to compare. Maybe we can just compare our notes.
You know what we could do, Tim, is we could actually say that I've been thinking about this, and we're making a live announcement here before the public of a possibility. I've been thinking about the fact that sometimes on the curriculum, we don't really need a whole Prezi or something like that. It could just be a couple of Instagram posts strung together, and then ask the questions inside the Instagram posts. So for the whole week, people can then be answering what they notice and what they see on it. So maybe we want to actually take this issue onto Instagram for a while.
Cool.
And have it just be on Instagram, and then see if we want to make some TikToks out of it and stuff like that. But just maybe let's start this out. So I think this is maybe a way we can do this. So we may not come back on live stream with this issue for a few weeks, but we could maybe curate this Instagram and ask different lawyers to take a look and see what they think of our work as we're going. And so then we can, and people in the audience can be participating in this too. So we can break down the different sections of the learning and let people share what they notice in the comments.
Question for you.
Yeah.
Is there a way, I'm wondering about people who may not be on Instagram.
We don't have to limit it just to Instagram. Yes.
Yeah.
So we can actually take the same curriculum and put it across all our social media, including Discord, including Instagram, including Twitter, including we can put it in different places and break it up in different ways, and kind of, and then we can also just have it on the website as a more formal curriculum, right? But then what we can do is when we've got a couple pieces percolating with a little bit, then we can come back with a whole opinion and read the whole thing together, and have an audience of people who've been thinking about this with us, perhaps.
I mean, yeah. Or another approach could be a Google form with the 5 sections as proposals for input or feedback. Like, what do people notice? And then let the Google form organize all the answers into a spreadsheet that we can analyze at the next meeting or something.
We could do that too. I think that would be cool.
Or a survey.
Yeah, no. I think why not, right? Why not? Why not have different ways of exploring this stuff together?
Because then we can let the form organize the data for us.
Well, we can certainly see how the data gets organized with the form, and we can and see what patterns we might find in it that can help us organize more.
Yeah, let's see if that gets us some results. Because if it was just the two of us, we would be filling out our own forms, like taking our own notes. But if we just let the form be something that we put our information on, and then we can open that to others to do the same, it'd sort of be the same thing as allowing the Instagram or whatever platform to do that kind of outreach.
Well, the Instagram has the distinct difference that it's a more open forum, and it's very simple, and it's very easy to orchestrate the different evidences carefully. It offers a different kind of tactile experience, perhaps, to people, which isn't to say that one's better than the other. Is to say that they might have different, they're different experiments potentially.
Right.
And so But like, for instance, the benefit the Instagram might have is that it allows us to facilitate these conversations, or whether that's Instagram or whether that's Discord or however we want to do it in social land. But yeah, I think the form would be good too. It's just to say we can start doing some. We're going to start rolling out some experiments this week. So folks, keep your eyes peeled for our Instagram and our Facebook and Twitter. Some folks are tuning in on Twitter right now.
Or X.
Yeah, I know. I'm kind of rude about it because I do like calling it Twitter.
I'm like, what's Twitter again? Oh, wait.
Yeah.
Twitter.
Right?
I'm on Twitter all the time.
Yeah. So, okay. So this is good. We've got a plan here.
Can we repeat for the dissenting opinion? I mean, would that be a well-rounded approach if we looked at the majority opinion?
I guess we
repeated the analysis for the dissenting opinion. Then maybe the next gathering, we could sort of step back and say, okay, what just learned is that some are arguing for this and others are arguing for that, right? And it's like, this.
Do you want to do the dissenting opinion now? We could, or do we want to, or should we? Or we can wait. We can wait for it because I know
it's almost 10:40.
Yeah, that's fine.
9:40 at your place.
But let's wait because we've done a lot of work tonight already, and we've already done a lot of work. And frankly, I think that we can break the dissenting opinions up in that way too. And also we can make some short videos and stuff. Like there's a lot of stuff we can do in this.
Whoa.
Yeah, like there's some stuff we can do to set up some stuff. So we're gonna wrap up here. And if you enjoyed what you saw today, you're always welcome to drop by Code Whatever, our website, and on our website, I'm going to put a link to the website again. That's codewhatever.us. You can find our different events on here. There's all kinds of things that we have going on every week. You can donate to us, and you can also just reach out. You're also welcome to just reach out. I'm BA at codewhatever.us. So feel free to reach out. And if you'd like to get involved or whatever, if you want to donate time or money, everything helps. Anything else from you, Tim?
No, I think this has just been really wonderful. If you are feeling threatened by the current decisions being played out in politics and the Supreme Court, and you want to learn more, this is how you do it. You roll up your sleeves and you have to pay attention, and you have to bird dog what's happening. And I'm just really thankful to have this kind of space and time to do this work.
Same here.
Hopefully we can it'll pay off by educating ourselves and others about what just happened, and we can all start to gain some perspective about where we are, because I've heard we're heading into a time of rising authoritarianism. And if you just back up a little bit and you look at all the appointees, recent appointees, not the most recent, but the Supreme Court's been and it always has been in flux, and there might be some reason that we can deduce from the evidence about the majority opinion. And how it supports the this new place in history that we find ourselves in, this new moment, and how this new moment might be a dangerous one. If we get into the dissenting opinion, we might learn, whoa, something's going on here. Yes, it's unprecedented, and it might be okay or not, depending on what we learn. So.
Yeah, there's going to be a lot that we can explore here. And I want to just say that as we explore this more, we have a chance here not just to learn what the human rights are about this issue and to practice debating that with each other, to practice advocating that as if we were going door to door, to practice all kinds of skills to help each other learn about this, just as we're learning about this right now. So we'll be back next week, same time, same station or stations. And thank you so much. Thank you, Tim. This is great.
You're so welcome. It's my pleasure. Thank you. This is quite the smorgasbord of formats and resources, and it's all sort of, it's a pleasure to just manage them with you and go through them all with you. Thank you for all of the work you've done in setting up these resources. I'm putting them in the document right now on a second page so that we don't lose them.
Yeah, and we'll put in the comments here the document itself too, a link to the document. In fact, I'll do that. I will do that actually right now, so that anybody with a link at least can view and comment. And I'll put that in the chat now. Thank you so much, everyone. Thank you, Tim. We'll see you next week.
Bye. Good night.
Yeah. Good night, everyone.